Hello students, I'm Swati Singh Parmar, Assistant Professor, Dharmashastra National Law University, Jabalpur, Madhya Pradesh. Today we will discuss about international courts. We will discuss in detail about the International Court of Justice and International Criminal Court. So let us begin today's discussion. In our today's discussion, we will talk about these things. First, we will discuss the international courts in general. Then we will come to International Court of Justice, after which we'll discuss the United Nations Charter provisions relating to the International Court of Justice. Then the Statute of International Court of Justice. Then we will move to the members of International Court of Justice. We will also look at the jurisdiction of International Court of Justice. After this, we will move to the International Criminal Court. We will first see a brief introduction of the International Criminal Court, after which we will look at its jurisdiction. Then we will see the legal process involved in it, and then we will look at a few important cases decided by the International Criminal Court. So, what are international courts? International courts are more or less, or in layman's term, we can say that they are similar to the national courts, similar in their adjudication process, but their ramifications, the ramifications of the decisions they take may be very different from the national courts. But to understand, we may see international courts as adjudicatory bodies or judicial organs at international level. Usually, the international courts are established by some treaty or a convention. So, if we talk about the International Court of Justice, it was established by the Charter of the United Nations and the Statute of the International Court of Justice. Now, as another example, if we look at the International Criminal Court, it was established by the Rome Statute. So, Rome Statute for International Criminal Court and UN Charter plus Statute of International Court of Justice for International Court of Justice are the treaties that established International Criminal Court and ICJ respectively. Then there are different varieties of international courts and tribunals. It's not necessary that the international courts that we witness in today's world are related to United Nations only. There are other bodies which may be independent of United Nations. So when we talk about International Court of Justice, as we have discussed in one of the previous lectures when we discussed about the United Nations system, we discussed that there are 6 principal organs of the United Nations and International Court of Justice is one of them. So International Court of Justice is one of the principal organs of the United Nations. But beyond United Nations, there are other international courts as well. So for example, also within the United Nations, there can be temporary tribunals set up from time to time on a case-to-case basis. So, for example, the United Nations Security Council, another principal organ of United Nations, can set up temporary or ad hoc criminal tribunals to look into a specific issue. So, ad hoc criminal tribunals, which are established by the United Nations Security Council, are another category of international courts and tribunals. There can be yet another category, which I said that it can be beyond United Nations scheme also. So these are the International Criminal Court and the International Tribunal for Law of Sea, or ICJ in its abbreviated form. The International Criminal Court and the International Tribunal for Law of Seas are independent of the United Nations. They are not part and parcel of the United Nations as an ad hoc criminal tribunal, or ICJ are. So ICC and its laws, these are established by documents, by conventions and treaties, which were drafted within the United Nations, because the United Nations has a specific body devoted to drafting of international treaties and conventions, which is named International Law Commission. So it was the constituting document of International Criminal Court and International Tribunal for Law of Sea was drafted within the United Nations, but these outcomes, these courts and tribunals, are not part of the United Nations. Then there can be other international courts and tribunals also, which are very independent from United Nations. Now, let us focus on International Court of Justice. And in the right bottom of the slide, you all can see a building. This building is the place from where International Court of Justice operates. This building is known as the Peace Palace. So International Court of Justice, or ICJ in short form, was established by the adoption of the Charter of the United Nations and a document which is annexed in the Charter, which is the Statute for International Court of Justice. The Statute for International Court of Justice is a document specifically devoted to the International Court of Justice, while the Charter of the United Nations talks about other principal organs and other subsidiary organs of International Court of Justice of United Nations. Now, International Court of Justice is the principal judicial organ of the United Nations, and this is mentioned in a specific provision of the Charter. Article 7 of the Charter of the United Nations says, there are established as principal organs of the United Nations a General Assembly, a Security Council, an Economic and Social Council, a Trusteeship Council, an International Court of Justice, and a Secretariat. So Article 7, when it mentions about the 6 principal organs of the United Nations, it mentions International Court of Justice as one of them. Also, International Court is seen as a successor of the Permanent Court of International Justice. Permanent Court of International Justice was an international level court that decided the disputes between the states, and it was contemporaneous to the League of Nations. So when in 1920 onwards, the League of Nations started functioning, the Permanent Court of International Justice also used to function during the same duration, the same time period. But having said this, it is important to note that as ICJ is an integral part of the United Nations, PCIJ, or the Permanent Court of International Justice, was not a part of the League of Nations. Permanent Court of International Justice was an independent judicial organ. Permanent Court of International Justice used to operate from this same building which we just looked at. It is the Peace Palace. International Court of Justice is situated here, the Peace Palace, which is situated in The Hague, the Netherlands. And the role that International Court of Justice performs is twofold. One, where it settles the disputes between states, where the states submit a dispute to the International Court of Justice. And second, where any United Nations organ requests for an advisory opinion of the court, then the court can give an advisory opinion on any of the legal questions which are referred to it by the United Nations agencies. And for it, one can look at the article number 36 of the United Nations Charter, which talks about the power of United Nations Security Council to refer a matter, to refer a legal question for advisory opinion to the International Court of Justice. Now, let us look at the provisions of the Charter of the United Nations with respect to International Court of Justice. We'll look at three provisions. First is Article 92. Article 92 reads, and I'll read, the International Court of Justice shall be the principal organ of the United Nations. So, beside Article 7 that talked about the principal organs of United Nations, the 6 principal organs of United Nations, Article 92 is the one that specifically mentions International Court of Justice to be the principal judicial organ of United Nations. So, International Court of Justice shall be the principal judicial organ of the United Nations. It shall function in accordance with the annexed statute, which is based upon the statute of the Permanent Court of International Justice and forms an integral part of the present charter. So, as I mentioned before, that in the Charter of the United Nations, there is an annexure. The annexed document is titled as the Statute of the International Court of Justice, and it is the document that governs how International Court of Justice has to function, how many members are to be there, what should be the term or duration of membership, how the members are to be elected, etc. So, Statute of International Court of Justice is an annexure to the Charter, and therefore it is an integral part of the UN Charter, and it focuses on International Court of Justice. Also, the Statute of International Court of Justice is based upon the statute of its successor, that is the Statute of Permanent Court of International Arbitration, International Justice that we just discussed. Now, after Article 92, another significant article of the Charter about ICJ is Article 93. Article 93 has 2 paragraphs. The first para reads, all members of the United Nations are ipso facto parties to the Statute of the International Court of Justice. So this says that the state parties, which are the states which are members of the United Nations, they become automatically the members of the Statute of International Court of Justice. Now, the second paragraph talks about those members which are not the members of the United Nations. So, para 2 of Article 93 reads, a state which is not a member of the United Nations may become a party to the Statute of the International Court of Justice on conditions to be determined in each case by the General Assembly upon the recommendation of the Security Council. So it says that a party which is not a member of the United Nations, it still can become a party of the Statute of International Court of Justice. How? This can happen on certain conditions which should be fulfilled by that state, and these conditions are to be decided by whom? The General Assembly, upon the recommendation of the Security Council, can decide these conditions from case to case basis. So for each state, the conditions may be customized, the conditions may be different as the General Assembly and Security Council decide. And upon fulfilling those conditions, the state can be considered to be a member of the Statute of International Court of Justice. So in that sense, Article 93 is significant because it talks about members of United Nations being the members of Statute of ICJ automatically. Then it talks about the non-members of United Nations and how can they become the members of the Statute of International Court of Justice. Now, this is important in looking at the cases where a state is involved which otherwise is not a member of the United Nations. Now, third important provision of the Charter of the United Nations regarding ICJ is Article 96. Article 96 reads, The General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. This we discussed in our previous slide, that the General Assembly or the Security Council or any other United Nations agency, if it faces a legal question and it deems fit that ICJ's advisory opinion is needed in this, then it may refer that legal question to the International Court of Justice for its advisory opinion. So, as far as the Charter of the United Nations is concerned, with respect to International Court of Justice, we must be mindful of Articles 92, 93, and 96. Now, these are the generic provisions about International Court of Justice that are mentioned in the Charter. Now, let us zoom in to the Statute of International Court of Justice, which is a document devoted completely to the International Court of Justice. Statute of International Court of Justice. Now, we will look at the scheme of the statute so that we know the broad categories of things that the statute talks about. So, the statute is divided into several chapters. Chapter 1, that has Articles 2 to 33, talks about the organization of the court. Chapter 2, which is from Articles 34 to 38, talks about the competence of the court. Chapter 3 talks about procedure. It has Articles 39 to 64. Then comes Chapter 4 from Articles 65 to 68. It talks about the advisory opinion of the International Court of Justice. Chapter 5 talks about the amendment to the Statute of International Court of Justice. Articles 69 and 70 deal with it. Now let us look at the members of the court. Article 3 of the Statute of ICJ says that there should be 15 members in the International Court of Justice. It also highlights that no 2 members out of these 15 should be the nationals of the same state. So out of the 15 member judges of International Court of Justice, no 2 members shall have the same nationality. Then Article 4 talks about the election of members. Members of International Court of Justice are to be elected by 2 bodies of United Nations, which are the General Assembly and the Security Council. So General Assembly and the Security Council, they draw the members to be elected, and this is drawn from a list of persons which is nominated by the national groups to the Permanent Court of Arbitration. So the national groups nominate their legal experts to the Permanent Court of Arbitration, and from this Permanent Court of Arbitration's list, it is the United Nations General Assembly and the Security Council that they, from this list, draw certain members which are candidates for election to be elected as the members of International Court of Justice. So there are 3 important pillars here. General Assembly and Security Council, they decide from a list, and the list is from the Permanent Court of Arbitration, and this list is given by the national group. Now, Article 19 talks about representation in the court, and this is significant because it says that the representation of major civilizations and principal legal organs should be kept in mind during the election of the members of ICJ. So while Article 3 highlights that 2 members should not be from same nationality, Article 9 adds a layer to it by saying that it's not only that nationality should not be common, but also we should take care of the civilizations and legal systems representation at ICJ. So the principal legal systems should be represented. The main forms of civilizations should be well represented at the International Court of Justice. And these are the things that should be kept in mind by UNGA, UNSC, and during the election of the members of ICJ. Now, Article 13 talks about the term of membership, and it says that the term of members of International Court of Justice shall be 9 years. Also, the members of ICJ may be re-elected. So, re-election is an option for the members of ICJ. So, for example, in case of an Indian judge, Justice Dalveer Bhandari, who had served one term at International Court of Justice, he has been re-elected for a second term for the membership of the International Court of Justice. He still is serving at the ICJ. Now, after looking at the membership of International Court of Justice, now let us move to the jurisdiction of International Court of Justice. The jurisdiction of ICJ draws from the twofold function that it performs, which I discussed a while ago. And it is the contentious jurisdiction and the advisory jurisdiction. Contentious jurisdiction is the jurisdiction that gives the court the power to settle disputes between the states. So whenever two or more states have a dispute between or among themselves, and the dispute cannot be settled by the two or more states by way of mediation, conciliation, negotiation, or any other pacific mode of settlement of dispute, then they may choose to go to ICJ to settle their dispute. It's important to note here that two or more states which are involved, so all the states which are disputants, which are the parties to the dispute, must submit to the jurisdiction of International Court of Justice. Submit to the jurisdiction means that they must consent to the jurisdiction of ICJ. If they do not consent to the jurisdiction of ICJ, ICJ usually does not take a matter ipso facto. It cannot decide a matter on its own. It can decide a matter only when the states want it to decide a matter. So both or all the states involved in a dispute must agree that ICJ should decide our matter, should settle the dispute between us. Also, it's only the states which can appear before the International Court in its proceedings. So that would mean that private entities, for example, international organizations, non-governmental international organizations, or individuals cannot appear before the court. One provision that is important for us to note from the Statute of International Court of Justice is Article 35. Article 35 lays down the conditions under which the state may approach the court for settling dispute between them. Article 35 is divided into two parts, paragraph 1 and paragraph 2. Paragraph 1 says about the state parties to the statute of ICJ, while paragraph 2 talks about the states which are not the parties to statute of the ICJ, and how these two categories of states can access the court is mentioned in Article 35. Another kind of jurisdiction that the court has is its advisory jurisdiction. And as we discussed, that advisory jurisdiction is seeking an advice of the court by any of the United Nations agencies. So, a request in writing may be given for an advisory opinion of the court, and this request may be given to the registrar by the United Nations Security Council, United Nations Secretary General, or the director. This United Nations Secretary General or the director may address a letter to the registrar, and this letter may be a written request seeking for advisory opinion of the International Court of Justice. So, contrary to judgments, the advisory opinions given by the International Court of Justice do not have a binding force. So, the judgments that are given under the contentious jurisdiction that we just discussed are binding upon the disputant parties. But an advisory opinion, when it is given by the International Court of Justice, then it may not have the same binding force, except in situations where the advisory opinion itself mentions that it will have a binding force. So, the general rule is that advisory opinions do not have a binding force, as the judgments of the court have. Second, which is an exception, an exception to the rule is that sometimes the advisory opinion of the court may itself mention explicitly so that this shall have a binding force. Only in these situations, advisory opinion will have a binding force, otherwise not. Also, it is important to know that these do not have binding force even for the legal entities that request for its advice. So the requesting organ, suppose a General Assembly, Security Council, or any other United Nations agency, which requests for an advisory opinion of the court, it is not bound by the advisory opinion. So the agencies, the requesting agencies, are still free to decide regardless of what the advice of ICJ is. Now, having discussed that there's no binding force of the advisory opinion of the court, still, it's important to highlight that still the advisory opinions of International Court of Justice have a very high legal weight, and they are popular and celebrated opinions of the court. So these advisory opinions are widely quoted within the international law academia. And to show you all a glimpse of significant advisory opinions of the court, I have few illustrations. So first example is the advisory opinion given in the year 1996, and this advisory opinion was on the legality of the threat or use of nuclear weapons. This is a very significant document, and it is widely quoted whenever the question of nuclear weapons and the legal and moral questions around it are invoked. The dissent given by Justice C. Veeramantri, a international legal stalwart, his dissent in this advisory opinion is also widely quoted. So this advisory opinion is a very significant one. Another example is the 2019 advisory opinion of the court, and it was regarding the legal consequences of the separation of Chagos Archipelago from Mauritius. Again, this is a widely quoted, celebrated advisory opinion of the court. Then is the recent 2024 advisory opinion on obligations concerning the occupation of Palestinian territory. I would advise all our viewers to go on the official website of the International Court of Justice and look at a few advisory opinions given by the International Court of Justice. If possible, then maybe find these advisory opinions and have a look at how advisory opinions are. Now, having discussed about the members, the jurisdiction, and a few significant advisory opinions of the court, now let us start our discussion on International Criminal Court, or ICC in abbreviation. International Criminal Court is an independent judicial body, unlike ICJ. So ICJ that we just discussed about is a principal organ of United Nations, but International Criminal Court is independent. It is not a part of another international organization. So in that sense, it is an independent judicial body. It is also situated at The Hague, the Netherlands. International Criminal Court was established after the need of having an international court was felt by the global community, especially after the temporary tribunals that was set up in the 1990s to look at the atrocities and crimes committed in the former Yugoslavia and Rwanda. So, Yugoslavia and Rwanda and the grave human rights violations and atrocities committed there were significant flashpoints, after which some temporary international tribunals, ad hoc international tribunals, were set up. And it was at the same time, it was felt that there is no permanent body that can look into international crime. And with this sense, an international court of International Criminal Court was established. Now, International Criminal Court was established with the treaty Rome Statute in July 1990. So, Rome Statute is the constitution of International Criminal Court. It is the founding treaty of International Criminal Court. International Criminal Court began its functioning from the year 2003 because Rome Statute had a provision, which several treaties have, that there is requisite number of members which, when sign and ratify this treaty, then this treaty would come into functioning or come into operation. So, Rome Statute had this provision that after being ratified by a minimum of 60 member states, then the functioning of International Criminal Court would start. So, 60 state parties signed and ratified Rome Statute till 2003, after which the International Criminal Court started its function. So, although the Rome Statute was created in the year 1998, and this Rome Statute established ICC, but ICC will start functioning only when the requisite number, that is 60 states, will become parties to Rome Statute, which happened in 2003. Now, this court acts as a court of last resort to prosecute criminals who have committed most heinous atrocities or offences against humanity. So, in that sense, the national courts have a primary level of functioning for any of the crimes or heinous offences. But in situations where national courts are not willing to or do not have the capacity to deal with heinous offences, in that situation, the International Criminal Court may step in. Now, the role of International Criminal Court is to investigate, prosecute, and try individuals who have committed most heinous offences. There are 4 categories of international crimes that the International Criminal Court deals with. The first category is genocide. Genocide is an act which is committed with a specific intent. So, a specific intent is important, and the specific intent to commit genocide should be there to constitute the act of genocide. And the specific intent is to do what? Is to destroy in whole or in part a national, ethnic, racial, or religious group by killing its members or by any other means. These any other means can be causing serious bodily or mental harm to the members of a group, deliberately inflicting on a group conditions calculated to bring about its physical destruction in whole or in part. So, for example, stopping food, stopping water, making the situation so harsh, which is calculated to bring physical harm or physical destruction of the entire group or a part of the group. Another example could be imposing certain measures which are intended to prevent hurts within the group, or forcibly transferring children of the group to another group. So these are examples or illustrations through which the act of genocide is committed. Another category of international crime is crimes against humanity. And crimes against humanity are serious violations which are committed as a part of large-scale attack against any civilian population. The Rome Statute mentions 15 forms of crimes against humanity, and some of which are murder, rape, imprisonment, enforced disappearances, enslavement, particularly of women and children, sexual slavery, torture, apartheid, and deportation. The third category of international crime is war crimes. War crimes are grave breaches of the Geneva Convention. They're committed in case of an armed conflict or a wartime situation. They include certain category of crimes. For example, the use of child soldiers in case of an armed conflict, where child soldiers are trained and forced to participate in war. The killing or torture of persons such as civilians or prisoners of war or POWs. Then intentionally, directly attacking against hospitals, historical monuments, buildings that are dedicated to religion, education, art, science, or charitable purposes. The fourth category of international crime is crime of aggression. It is use of armed force or physical or military force by a state against another state. So whenever a state uses armed force or military force against another state's sovereignty, integrity, or independence, then it is said to have committed a crime of aggression. Initially, genocide, crimes against humanity, and war crimes were three major categories of crimes mentioned under the Rome Statute. So this fourth category, the crime of aggression, was added at a later stage. It was adopted by amending the Rome Statute at the first review conference of it in Kampala, Uganda in the year 2010. So it was 2010 when crime of aggression was considered to be added and was added by way of amending the Rome Statute. If we talk about the jurisdiction of International Criminal Court, the jurisdiction of International Criminal Court is over the four category of offences or four category of international crimes that we discussed. Now these crimes, in case where ICC has a jurisdiction, these crimes are the ones which were committed by either by a state that has ratified the agreement or by a national of such. So, International Criminal Court will have jurisdiction over the offences only when these crimes are committed in a state which has ratified the Rome Statute, or these crimes have been committed by a national in such a state. So, a state where the state has not ratified the Rome Statute, or a national of a state where the state has not ratified, such national or such state, only over these categories will the International Criminal Court have its jurisdiction. So where a state has not ratified the Rome Statute, the ICC will not have a jurisdiction over it. Or where a national has committed an international crime and that national belongs to a state where that state has not ratified the Rome Statute, even in that case, for that national, the ICC will not have a jurisdiction over it. This ICC can have jurisdiction in the in cases of any of the four crimes, and this has a prospective jurisdiction, so it can have jurisdiction only after it came into function. So only after 1st July 2002, whatever crimes were committed in that situations only, the court will have jurisdiction. The court will have jurisdiction only where the crimes are committed by state party or state party national, or in the territory of a state party, or in a state that has accepted the jurisdiction of the court. So, if a state has not accepted the jurisdiction of the court, or it has not signed and ratified Rome Statute, in that case, ICC cannot have jurisdiction over that state or over that state's individual or over a crime that has been committed in the territory of that state. Also, the crimes that are referred to the International Criminal Court prosecutor by the Security Council of the United Nations under Chapter 7 of the UN Charter, for these crimes also the International Criminal Court will have a jurisdiction. So, International Criminal Court will have jurisdiction for two broad category of things. One, where the state has signed and ratified Rome Statute, that is, the state has expressly accepted the jurisdiction of International Criminal Court. In that case, for that state, for the national of that state, or for the territory of the state, the ICC will have a jurisdiction. Second, ICC will also have a jurisdiction in situations or matters which are referred to it by the Security Council of the United Nations. And the Security Council of the United Nations does so under Chapter 7, which is measures taken to safeguard international peace and security of the United Nations Charter. Now, some significant points to note about the International Criminal Court. So, International Criminal Court functions on a principle of complementarity. So, the court is intended to complement the national criminal systems, and it is not intended to replace the national criminal system. I just mentioned that national courts still have jurisdiction over the heinous crimes committed within its territory, committed by the nationals of it, etc. But only where the national courts are unwilling or incapable due to some issue that they cannot try such individuals or prosecute such individuals. In that case, the ICC is meant to come as a court of last resort. So ICC is to complement and not to replace the national court system, the national criminal system. Also, ICC will prosecute cases only when states are not willing to do so or are unable to do so genuinely. It is important to note that the court does not have a police force of its own or an enforcement body, and it depends upon the nationals, the nations for their police force or enforcement of the ICC decision. So it relies upon the cooperation of the states to support ICC, and the support is usually in these areas. So support may be for making arrests of international criminals. It can be for transferring an international criminal or an arrested person from a jurisdiction to the ICC detention center, which is situated in The Hague. It can be to freeze the suspect's assets. It can be to enforce a certain sentence that has been delivered by the International Criminal Court. Let us now look at the legal process or the stages involved where international crime has been committed. So once an international crime, any of the four that we discussed, so once an international crime has been committed, these are the stages that usually follow. So first, there are preliminary examinations that are conducted by the prosecutor of International Criminal Court to weigh the gravity of evidences, to weigh the availability or existence of evidences, and therefore to find the gravity of the crimes committed. So whether a crime has been committed, or if committed, then whether evidences are there so as to tell us about the weight of the international crime. This preliminary examination is conducted by the International Criminal Court's prosecutor. After the preliminary examinations have been conducted and it has been concluded that evidences are present and a grave international crime has been committed, then the investigations begin. Investigations begin where the International Criminal Court's prosecutor may request the ICC to give arrest warrants or to give summons to the suspects to be present before the court. Once the investigations have taken place, then the pre-trial stage comes in, which is the initial appearance of the suspect in the matter. And here, three judges of the International Criminal Court tell about the charges in detail to the suspect and make the suspect understand the charges and the ramifications of it. It is also regarding the authenticity of the person involved, regarding uh, knowing the identity of the person and agreeing that, okay, this is the person who was actually the suspect and it is not a dummy person or some other person appearing on his behalf. After the pre-trial stage, there is the trial stage. And once the trial stage has concluded and a person has been convicted or acquitted, so if the person has been aggrieved of the decision taken by International Criminal Court, in that case, the person can go for the appeal stage. In case of appeal, till the trial stage, there are three judges involved. In case of appeals chamber consists of five judges of International Criminal Court. After the appeals stage, if the appeal has failed or sustained, and depending upon the result of it, there is the last stage, which is the enforcement of a sentence. If a sentence has been given by the International Criminal Court, the last stage is the enforcement of it. So these are the broad stages of uh, legal process that are involved in deciding a matter by the International Criminal Court. Now let us look at some key cases decided by the International Criminal Court. The ICC began its first hearing in the year 2006, where Thomas Lubanga was held guilty for an international crime of recruiting child soldiers in the Democratic Republic of Congo. The trial of Thomas Lubanga began in the year 2009, and by 2012 it was concluded, where the ICC found him guilty of these crimes, and the ICC imposed a 14-year imprisonment of Thomas Lubanga. Another case where in May 2007, arrest warrants were given for the ministers of Sudan for committing the international crime of crimes against humanity by Sudanese forces in Darfur. Another instance is from the year 2019, where in November 2019, the International Criminal Court began investigating crimes by the forces of Myanmar against a Muslim minority situated in the Rakhine states, the north state of Myanmar, who are known as Rohingyas. Another recent instance is from March 2022, where the court announced investigations into the crimes committed in Ukraine by the Russian forces. After a year, in March 2023, arrest warrants were given for Vladimir Putin, the president of Russia, for his responsibility for the war crimes of unlawful deportation of Ukrainian children. These were the few important ICC cases, and with that, I want to conclude. In our today's discussion, we talked about international courts and the nature of international courts in general. Then we focused on International Court of Justice. Within it, we talked about the provisions of the Charter of the United Nations with respect to International Court of Justice, in which we discussed Articles 92, 93, and 96. Then we talked about the jurisdiction of International Criminal Court, where we talked about contentious jurisdictions to settle disputes between parties and advisory jurisdiction to serve an advisory opinion to any of the United Nations agencies. We also talked about the binding force of advisory opinion. After this, we talked about the members of ICJ, their election, then their term, and then about their re-election. Then we came to another court, which is International Criminal Court. We talked about the brief background of it, and then we talked about the members of International Criminal Court, the jurisdiction of International Criminal Court, and the 4 categories of international crimes that it deals with. Then we talked about a few important key cases decided by International Criminal Court. With that, we have come to the end of today's discussion. In the end, I want to suggest all our viewers to please go to the official website of the International Court of Justice and the International Criminal Court and look at the About section or Home section of it and just go through different tabs so as to understand different things that the International Criminal Court or International Court of Justice are involved in. With that, I'll mark an end to our today's discussion. Thank you so much, everyone.